Good afternoon. We're just going to give it another minute or two just to let a few more people join to make sure we don't get ahead of anybody. So just hang in there, please. All right. Well, we are going to go ahead and get started. So first of all, good afternoon. So great to see so many small business owners, nonprofit leads, HR professionals on this call. I'm grateful for the response that we had and coming and learning a little bit more about this topic. So our topic for today is stay compliant, stay confident, mastering employment law basics. First things first, my name is Nate Damaris. I am the owner and principal consultant of Rooted HR. Looking forward to kind of doing a broad brush, high level on employment law basics for your organizations, where I think there can be some major implications if not handled appropriately. So, looking forward to again helping you stay compliant and stay confident. And with that, we'll just kick it off here. So no good HR presentation would not be complete without a disclaimer. So I'm just going to read the disclaimer to you. The information, recommendations, and guidance contained within this presentation are for general HR and compliance purposes only and do not constitute legal advice. I'm not acting as an attorney, and no attorney-client relationship is created through this training. For advice regarding the interpretation or application of any law, regulation, or legal requirement to your specific circumstances, please do consult with your qualified legal counsel. Just one quick housekeeping note. So I do have the presentation or the session in listen-only mode. That's simply just to avoid distractions and background noise. However, as you're engaging with the content as we go through it, if questions come up in your mind where you need clarification or just want to know something else related to what we're talking about, please do drop that in the chat. Happy to, at the end of the presentation, if time if we're availed the time to do that, I'm happy to answer questions on the call. If we don't get to some or all the questions, what I will do is I will create a Q&A, document that, and send that out to everybody after the call as a takeaway. So let's go ahead and jump right in. So just in terms of some context for why employment law matters, first of all, when you are following the law, and specifically employment law, it gives you the ability to potentially protect your organization from costly lawsuits. In a minute here, I'm going to give an example of a relatively small business that had some missteps, made some compliance mistakes that could have otherwise been prevented, and ultimately they went out of business as a result. So it can have significant implications if you're not following the laws at hand. Secondly, if you are interpreting the law and then basing your decisions appropriately on the law, you have the opportunity to ensure consistent and fair treatment of your employees. Now, the one caveat that I would make to that is consistent and fair doesn't always necessarily mean equal. I think we can all agree that people are humans and humans come to work with a variety of circumstances. And oftentimes, those differing circumstances can require a different course of action than maybe you would have taken with another employee. So, what I usually tell my clients is policies are super important, but they really are guidelines and parameters. They're not hard and fast necessarily. And sometimes you do have to make accommodations and kind of sidestep from those policies for specific circumstances. So, just wanted to point that out. Next, when you are following employment law, you have the opportunity to build trust and your organizational reputation. When word gets out, maybe because of a public lawsuit or just simply because your employees or former employees are talking about you, when word gets out that your organization is not abiding by the law or that you're highly inconsistent in your treatment of employees, really the court of public opinion can be pretty brutal. And so people are very quick to judge your employment brand and decide if you're a good place to work or not. And lastly, of course, employment law does help small employers and nonprofits avoid many common compliance mistakes. And we'll touch on a number of those today and hopefully help you prevent some of those mistakes in your own work. So as I mentioned, just to kind of get some perspective on why understanding and being compliant with employment law is super critical. So this is a California-based case, and keep in mind, in California, things do tend to be a little bit more complex, litigious. It's a totally different labor landscape in California. So this is a bit of an anomaly, but not outside the realm of possibility elsewhere. So an organization that went by the name of TLC Home Care Services, they were in the business of employing caregivers to go into homes and provide personal care. The reason I chose this case is this is a very common misstep for small businesses and nonprofits. They classified their caregivers as independent contractors instead of as W-2 employees. So what that meant was when they were compensating them, they were paying some of those caregivers as little as $120 a day for a 24-hour shift. Well, there's a couple issues with that, right? It came out to about $5 an hour, clearly not minimum wage. There was no overtime opportunity because they were contractors. They were not covered under workers' comp. They did not have the opportunity to apply for unemployment benefits once separated from the organization. A whole litany of issues. And the DOL essentially said these caregivers did not meet the very specific qualifications to be classified as contractors. And we'll talk about that a little bit later in the presentation. Ultimately, TLC suffered a $10 million judgment against them, and ultimately they just couldn't handle that and they are no longer in business. So just wanted to kind of point out an example, a little bit extreme, but it can certainly go in that direction because of a very small misstep. So wanted to talk a little bit about legal hiring. When you are in the hiring process, I would really encourage you to focus on essential job qualifications and use job descriptions that reflect the actual duties of the job. I mean, I've seen hundreds of job descriptions over the course of my career, and sometimes we throw the kitchen sink at it. And the expectations of those employees go far beyond, at least as written, go far beyond what we actually need from the person in that job. My encouragement to you would be when you are writing those job descriptions and when you are assessing applicants for employment, really focus on what is essential. It's really hard to defend employment claims when the duties of the job aren't really truly the ones being performed. Additionally, when you're in the interview process, if you focus on the essential duties, it kind of levels the playing field, right? So you're assessing all of the applicants on the same core functions. So having that consistency is important. I'm going to give you a couple of, they might come across as comical. I don't know. You might say, we would never ask this, but I can guarantee that these questions have been asked time and time again by certain businesses. But you want to avoid questions that are dialing into protected classes. So we'll talk a little bit about that later as well. But Protected classes could include things like race, color, national origin, age, disability, and the list goes on. But here's a couple of questions that really are not appropriate questions and violate discrimination laws. Number one would be, what is your immigration status? So immigration status is a protected characteristic. It's entirely appropriate to ask the person, are you legally authorized to work in the US? That's fine. But to flat out ask them your immigration status is definitely a no-no. Another question that would be a bad question would be, will your religious holidays affect your ability to meet the work schedule? Now, they might. They might be part of a religion that has holidays that are going to impact their ability to be at work. A better question would be, do you anticipate any difficulties with meeting the work schedule requirements? So you're not including religion in the question. Now, they might come back and say, well, I am of X religion and I can't work on certain days of the year. And then you can engage in that conversation around whether or not you're able to accommodate that. But leaving religion out of the question initially is the smart way to go. Not a good question to ask. Have you ever filed a workers' compensation claim? In the trades, in industries where injuries are common, I can see why you might be tempted to ask this question, because somebody who's filed a claim in the past, maybe that might be an indicator of them filing a claim in the future. Maybe, maybe not. But what you're asking really in that question is you're asking for medical information, which is not permissible. So stay away from that. And the last example I have for you is, do you plan to have children? Now, listen, I get it. As small businesses, as nonprofits, when you have somebody who goes on leave, whether it's for having a baby or a surgery or whatever, if you have a small team, especially, it's very difficult to manage that staffing challenge. But asking that question in the interview process it's not relevant to the job. And honestly, as the employer, it's on you to figure out how to staff your business when somebody goes on leave. So asking questions around having children, also not a good idea. Be consistent in your interview process. I usually recommend that you have a standard set of questions that are very specific to the job that you ask of all applicants for the job. That doesn't mean that you can't stray away from those questions or ask additional probing questions, but having that standard set of questions as a base is generally a good idea. Also, some employers, they might do some skills testing. So say you're hiring for a teacher, you might want them to do like a mock teaching assignment, get up in front of a classroom and deliver 20 minutes of content. If you're going to do that, that's great. It's a great way to see if they have the skills, but make sure you ask that of all of the applicants for that position. And then lastly, and this kind of goes without saying, document your hiring decisions. And we'll kind of talk about documentation a little bit later as well as to why that is so important, not just with hiring, but with all aspects of employment. So background checks. Background checks certainly serve a purpose. And the reality is in some industries, especially ones that are highly regulated, background checks are required. So criminal background checks, child abuse history clearances, and those kinds of things. What I would suggest that you do is when you're thinking about incorporating background checks into your process, really think about what is most relevant to the job. And then specifically with credit checks, generally, credit checks can certainly be completed on applicants, not a problem. But generally, you're going to only want to do credit checks when the person is handling money or has access to financial transactions. It's going to be related to the relevance to the job. One kind of newer thing I would say is, as a society, we've become much more in debt, right? And so when you run credit checks on applicants, it's become very commonplace to find people who have low credit scores, bankruptcies, unpaid credit cards, all of those kinds of things. My recommendation to you would be, if you are going to run credit checks on certain positions that have a direct connection to finances, think about your threshold of tolerance. So you don't want to make it so low that you end up with no applicants. You may want to think about a percent of debt as a percent of salary or something like that to kind of level the playing field. Because the reality is when you're hiring for lower level finance related employees, you're likely going to get a lot of folks with not so great credit. And you have to think through what is actually the risk to the organization of bringing somebody in with maybe just a couple of bad loans or whatever it may be. So just kind of give some thought to that. The last piece on this is something called the Fair Credit Reporting Act, or the FCRA. This essentially requires employers to give a concise notice to applicants that a background check will be obtained. It also requires you to get express written permission from the employee to run the background check. And then it also requires you to walk through a process called the adverse action notification process if you decide to not hire somebody based on the results of the background check. It's a very structured process. It's not hard to implement, but essentially it gives the opportunity to the employee who's being declined employment to offer other information to kind of mitigate the reasons why they have bad credit or something on their background check. So just be aware of the FCRA requirements and the documentation that goes along with that. I-9 verifications. It might seem pretty simple, but I've seen a lot of I-9s over the course of my career that are problematic. I've even had clients where they haven't even done the I-9s. It just wasn't even on their radar. And so the I-9 is a form that's required to be completed on every employee within 3 days of their hire. And essentially what it does is it authorizes them to work or shows that they have documentation to support their work authorization in the US. What happens is if the form is not completed and those work documents are not verified within 3 days, you essentially have to terminate the employee. So my recommendation is with your onboarding process, make sure that your new hires understand that they have to complete an I-9, make sure they have the list of acceptable documents. So they're coming on day one with the information that you need to be able to complete the form and you can move forward. Couple of kind of common mistakes around I-9s, photocopies cannot be used. So if you're doing a verification of those documents in person, it has to be the actual passport or the driver's license or whatever document they are providing. Now, in a day and age of people are dispersed, a lot of remote workers, there is a process that's available for remote verification. In that process, photocopies are acceptable, but you also have to use something called E-Verify as part of that verification process. There's a couple more steps you have to do for remote verifications. Obviously, be careful to fill in all of the fields, don't miss any signatures. And another common mistake is a failure to track which employees have work authorization documents that need re-verified. Some things with an expiration date need to be re-verified. A driver's license is not one of them. We all know driver's licenses expire. But like a green card, there's a list that is put out that says these are the documents that once expired have to be re-verified. So having a good tracking system, especially if you have a number of employees that are presenting documents other than the standard social card or driver's license, just understanding when those are coming up, getting in touch with those employees and getting those documents re-verified is super important. All right, so this actually directly ties back to the case study that we talked about with the home care company. So classification of individuals coming into your employ. Do you make them an employee on a W-2 on payroll, or can they be a 1099 independent contractor? The Department of Labor puts forth very, very specific guidelines around how to determine if somebody can be a contractor versus an employee. What it's called is the economic realities test. I'm going to cover a couple things here and then go to the next slide and talk about what that is. But it's a very refined checklist, if you will, to determine if somebody truly can be a contractor. The one thing I did want to specifically call out on this slide, and this is really speaking more to the nonprofit people on the call, is around volunteers. I've worked for a couple of nonprofits. I recognize how vitally important volunteers are to the success of the organization. but there are certain requirements that have to be met for volunteers to really be unpaid volunteers. So, according to the Department of Labor, volunteers can be unpaid if they offer their services for civic, charitable, or humanitarian reasons. Okay, that's easy, right? If they offer their services without expectation of compensation, which most volunteers do, they want to do it out of the kindness of their heart. They can be unpaid if they offer their services freely and without coercion. And then lastly, and I think this is the most important piece, volunteers can be unpaid if they are providing services in roles that do not otherwise displace paid employees. So if you have a situation where you've got volunteers doing work that employees would otherwise do, you might have a problem and may want to think about converting that volunteer to a paid employee. So just some things to think about that are more specific to the nonprofit space. So that economic realities test, um, and this has become especially significant in more recent times with the gig workforce and so many people becoming self-employed. Myself, a fractional HR consultant for small businesses and nonprofits. Like it's become a real thing, and there are a ton of independent contractors in the market at this time. So, under the economic realities test, a worker, and this is a very general statement, and then I'll talk about the six components here, but generally, a worker is an employee if they are economically dependent on the employer for work. So, kind of broad brush, that's what defines someone as being an employee, versus if they are in business for themselves, they're more likely, or they are an independent contractor. So if it were ever to become an issue, and so like in the case of that home care business, the DOL or Department of Labor would have looked at six different things. So they're going to look at, does the individual who is performing work for the company, do they have the opportunity for profit or loss? Is it completely within their realm of control that they can make money or not make money? Or are they just drawing down a paycheck regardless of how much work they performed? If it's the latter, they're probably more of an employee. Secondly, they're going to look at the level of investment in facilities and equipment. So things like, is the company providing a laptop, supplies, a cell phone, office space? If they're doing those kinds of things, more likely this person should be an employee. Secondly, is the permanence of the work relationship. A longer relationship that tends to be, I mean, nothing's permanent, but is more trending towards permanent, probably more of an employee versus a short-term stint or contract is going to be a contractor. Another big one is the nature and degree of control. So the DOL is going to say, how much autonomy does this person have? Are they able to make independent decisions? Are they just making recommendations to the company and the company can decide whether or not they're going to move ahead with that? If it's those kinds of things, yes, they're probably going to be an independent contractor. If there's a lot of control exercised, if they're I really can't make any independent decisions, it's probably going to lean more towards the employee relationship. And then two other smaller things they're going to look at is the work performed integral to the business? Essentially, is it something that somebody on the inside could typically do, or is it something that typically a third party vendor would provide? And then lastly, are there specialized skills required? Similar to that last one, but in the sense of would you typically see people in the company with those specialized skills to complete the work being done? Or does it require somebody to come in with a skill set that's not otherwise available in the company? So those are the kinds of things to kind of think about when you're thinking about independent contractor versus employee, because that's the lens through which the Department of Labor is going to look at those classifications if it ever were to become an issue. All right, so wage and hour, another kind of common area where small businesses and nonprofits can get tripped up. Minimum wage, not as much of an issue anymore because the labor market has become so competitive that there's virtually no companies paying close to minimum wage. And if they are, it's going to be really hard for them to compete. Still important, however, to recognize that different localities, different states have different minimum wage thresholds. So being aware of those is certainly key. Calculating overtime is another big one. So there is sometimes a misconception that overtime can be calculated over the course of a pay period. Most people's pay periods are going to be like half a month or a 2-week time frame. You cannot look at overtime on that period. You have to look at your overtime on a calendar week, and that can be Sunday to Saturday, that can be Saturday to Sunday, or Saturday to Friday. It can be whatever you define it is, but when you are looking at overtime, it's got to be for that payroll week. The other thing that is sometimes maybe a little bit unknown is that you don't have to pay overtime on all hours that are paid. You do have to pay overtime on all worked time, but not on non-work time. So what do I mean by that? When you've got PTO in the mix, you've got holiday in the mix, you've got other non-productive paid time, that is not time that factors into the overtime calculation. So let me give you a kind of a more concrete example. So let's just say that you have somebody who needs to get paid 42 hours for the week, but 8 of those hours are PTO. So that means they actually worked 34 hours, took the 8 hours of PTO. You're not going to pay overtime because they've gone over 40 because of the PTO. But let's just say same scenario. You've got somebody who is going to get paid for 42 hours. They worked 41 of those, like actually physically worked, and then 1 hour was PTO. You are going to have to pay overtime on that first hour over 40, but not the second one for the PTO. So it's just really important to understand like what factors into overtime and what does not. Certainly accurate timekeeping is a must. And then just a small note here, salaried doesn't automatically mean exempt. So I think there's an assumption that those two terms are synonymous. You actually can pay a non-exempt employee on a salary basis. Administratively, it's actually easier. You could just say, we want to pay Sally Sue X number of dollars for the week. She is a non-exempt employee because of the job duties test, but we're going to pay her this set amount. The problem then becomes that if you pay that amount, but then they actually end up working more than 40 hours in that week, you are going to actually owe overtime over 40. So you can do it, but at the same time, you still have to track the hours. So in most cases, it makes sense just to make them non-exempt, have them track their time, and then be very clear on when they go over 40 and overtime is something that is due to them. All right. So we've talked about classification, independent contractor versus employee, right? So now let's talk about how we classify those individuals who are employees of your company as exempt or non-exempt. And I would say this is another area where a lot of companies can get easily tripped up, even though the FLSA, the Fair Labor Standards Act regulations are pretty clear. So there's a couple of things or a couple of criteria that need to be met for somebody to be considered exempt or paid on a salary basis. So number one, minimum, they have to make at least $684 a week, which annualized is $35,568. That's the baseline requirement. If they make even $683 a week, they cannot be exempt. They must be paid on a non-exempt hourly basis. They also must be paid a fixed salary, not subject to any reductions. And we'll talk about that a little bit later in terms of not treating exempt employees as non-exempts with deducting from their pay for various circumstances. So if you meet those two things, that's a good start. So you might be able to have that person be exempt. But the more important piece is really the job duties test. So the Department of Labor, and again, the Fair Labor Standards Act, does a really nice job of outlining what is the scope of a position. What does the scope of a position look like where it can meet that exemption criteria, whereby you can pay the person on a salary basis and not have them be subject to overtime? So there's essentially 4 different types of exemptions. The first one that's pretty common is something called the executive exemption. So this is going to be somebody who typically manages a recognized department or division. They are going to supervise at least 2 full-time employees, And they have to have genuine authority over hiring, firing, promotions, and other significant personnel decisions. Now, just because somebody has the title of supervisor or manager or even, say, vice president, the title itself is not what drives the exemption status. It's really the scope of the work. So again, if they're managing, if they're supervising at least 2 employees, and if they have responsibility for hiring, firing, those kinds of things, most likely they can achieve exemption under the executive exemption. Second one would be people who are not necessarily in management, but fall under something called the administrative exemption. So these are going to be people who perform office work or non-manual kind of white collar work. So this is going to be work related to management and business operations. So think IT, HR, finance. Now, not every position in those areas will necessarily qualify because they also have to exercise discretion and independent judgment on significant matters. So if you've got an HR person, as an example, who really operates pretty independently, exercises a lot of discretion, say like an HR generalist would be a good example, they could be exempt. But you might have like an HR coordinator who's more responsible for processing paperwork, following a checklist, just following established procedures. That person is probably going to be non-exempt. Then the last two are considered professional exemptions. Some are learned professionals. So this would be like attorneys, engineers, pharmacists. It's essentially positions where an advanced level of learning was required to be qualified for the job. And then lastly is creative professionals. So oftentimes positions like designers, musicians, writers, they can be considered exempt level because of the originality, the invention, the imagination that they apply to their work. So there's a lot that goes into determining if somebody can be exempt or not, but I would say the most significant piece is probably going to be that job duties test. Just a quick example, at one of my former employers, we had inside sales reps. And we actually had those inside sales reps classified as exempt for a very long time. But the reality is, and I didn't really cover this, but another piece of this relates specifically to sales. If you're not doing at least 50% outside sales, like actually out of the office, meeting with clients, obtaining new business, you really can't be exempt. Well, we had this whole group of people classified as exempt for a long time. And under the regulations, once we identified that they truly should have been non-exempt, we were required to go back 5 years and estimate, which is a very hard thing to do if you're not tracking hours, but estimate 5 years worth of week by week, what overtime do we think those inside sales reps should have been eligible for? And then we had to make payments to them. So it's a very painful process on the back end if you've got somebody misclassified. It's better on the front end when you're hiring somebody, especially if you're creating a new position, to figure out what does that exemption look like and classify it appropriately. Other common wage mistakes. So off the clock work is not permitted for non-exempt employees. So if you've got an employee that is non-exempt, reporting all of their time, and they work, say, 45 hours in a week, well, they're over 40 at that point, right? So you owe them 5 hours of overtime. You can't just comp them that time and let them take off 5 hours somewhere else. You need to actually pay them for that time. Oftentimes I'll get the question, well, what if somebody worked the overtime without prior authorization? Well, that is a problem, right? Especially if your policy says that you have to get prior approval, but you still have to pay for that time because the time was actually worked. Now, does that mean that you can't address the issue with the employee and or subject them to progressive discipline for not following the policy? No, you absolutely can. You can let them know, like, you need to get prior approval for overtime before it's worked. And if you are working overtime without approval, we may subject you to corrective action. But that's different than having to pay for the hours that were actually worked. So be mindful of that. Training time is kind of a tricky one. So I would say most employers, if they are having their employees do training, they most likely are going to pay them for that time because typically it's a requirement of the job. It's something the company wants them to do or needs them to do, and it's typically going to be during normal working hours. There are times at which training can be non-compensated, but it has to meet very specific requirements. So there's 4 of them. So number 1 is the attendance at that training has to be outside of the employee's regular hours. Their attendance at the training has to be truly voluntary. There really can't be any pressure, no consequences for not attending. The training really can't be directly related to their employees, to their current job. And they also can't be doing any work, any productive work during the training. If any of those four conditions are met, the training time must be paid. So by and large, like I said, I think most employers are paying for training time, but there are certain exceptions where you don't have to, but you have to meet all four criteria. So just being mindful of when you're paying for training and when you're not is good. Auto deducting meal breaks seems like a great idea because we hope that people take a break in the middle of the day, right? I think it's good to take a lunch and kind of rest and decompress. But what if you are auto deducting meal breaks and that employee is so busy and ends up working through their meal break? You need to pay them for that time. Administratively, that becomes a problem. So it's better just to have people clock out and then clock back in after a meal break. Now, again, if they're working through that meal period, that is work time and is therefore compensable. And the last thing is another common wage mistake is treating those exempt classified employees as non-exempt workers. So what do I mean by that? It looks like a couple different things. It could be you have an exempt employee and you're requiring them to track all of their hours. Now, I know in certain industries, there's a tracking for billable hours, like an attorney or a CPA, like those kinds of things. But if you've got an average exempt employee where you're asking them to track all of their time, it makes them appear as though they are non-exempt and therefore potentially should be eligible for overtime. So be careful about that. Another one is requiring exempt employees to use PTO or paid time off in smaller increments than anything less than, say, a half a day. If you're asking your exempt employees to take PTO in 15-minute increments, 1-hour increments, it makes them appear as though they're non-exempt, and perhaps they should be non-exempt as a result. And even things like reducing their pay when they leave early on a given day or come late on a given day. When you have an exempt employee, you are to pay them based on the assumption that they will work the amount of time necessary to complete their jobs. Now, if you've got somebody who's consistently coming to work late or leaving early and not getting their work done, whether they're working 40 hours or less or more, that's a progressive discipline issue. But when you start to, you can't actually reduce their pay for those late ins and early outs. So I would imagine most people on the call today have an employee handbook or some version thereof. But really, when we think about employment law, there's a couple of key policies I wanted to call out that I think are very helpful to include. So certainly having a policy on anti-discrimination and harassment that addresses what are the protected classes, how are we going to make sure that the organization does not discriminate against those protected classes? And then the harassment piece as well, just addressing what does harassment look like? How are we going to prevent harassment? What is the complaint procedure? A statement around we are not going to retaliate against somebody who reports harassment or participates in an investigation, those kinds of things. Attendance and leave policies, just being super clear about what you expect as it relates to coming to work, calling off of work, and using leave time. Another important policy is going to be technology use. So what are the acceptable uses of company technology? And what are the consequences for not using company property or company technology appropriately? Confidentiality. So for nonprofits, this could be related to donors or clients. For small businesses in the company, it could be your customers. For all companies, it could be employees. But having a policy that really sets forth the expectations around maintaining confidentiality of all of those kinds of data. Code of conduct is another big one. I never suggest that it has to be a 100% exhaustive list of all of the behaviors that you expect or do not expect of employees, but creating a list of the things that you would generally expect to see employees demonstrate is helpful as part of your employee handbook. And then a complaint reporting procedure is also beneficial. I referenced this before with the protected classes, with anti-discrimination laws. The protected classes are many. There's race, color, national origin, sex, gender identity, gender orientation, religion. Those over 40 years of age are protected from an age perspective, disability, and pregnancy. There may be some organizations on the call, specifically in the faith-based nonprofit sector, that have some exemptions or some protections under the law as it relates to religion. But by and large, all of these laws are going to apply to all employers, regardless of profit or not-for-profit status. So your obligations under those anti-discrimination laws, you are expected to provide reasonable accommodations. Now, I do want to mention specifically with regards to the protected characteristic of disability. Only employers who have 15 employees or more are subject to the requirements of the ADA, or the Americans with Disabilities Act. So what that means is when you have an employee who is otherwise qualified for the role that they are applying for or that they have been hired for and they're performing, if they are otherwise qualified but have also a disability, you are required to engage them in a dialogue around what is it that we can do to assist you in completing the job tasks in spite of your disability. So looking at things like maybe the employee has some visual acuity issues. So you're looking at creating a different kind of screen with a larger font. Or maybe you have an employee who uses a wheelchair and there's some accessibility issues. They're qualified to do the job that they're doing, but they just need some additional modifications to the work site to be able to get to their desk successfully and safely. So any of those kinds of things. Now, for all of the other protected characteristics besides disabilities, all employers of all sizes are required to create accommodations or to look at accommodations. The biggest one that probably hits most employers is going to be the religious accommodation. So maybe you have an employee that is of a certain religion, and as I mentioned before, can't work certain holidays or certain days. That may be an opportunity, or really is an opportunity, for you to engage in a dialogue around how can we do some schedule adjustments that don't create an undue hardship on the organization or on your coworkers, but still allows you to have the time off that you need to celebrate the religious holidays that you recognize. So those are your obligations as it relates to accommodations. Your other big obligation is to prevent and promptly address harassment. And I don't care what organization you're a part of, it can happen and it does happen. The prevention piece is really around your policy, and it's really around training, especially for supervisors, to help them understand what does harassment look like, how should it get reported, when do we report it, who do we report it to, and also making sure that in situations of actual harassment that gets investigated and is founded, that we don't retaliate against those employees who allege the harassment or participated in the investigation of the complaint. And then lastly, to avoid retaliation. That's another big piece of your obligations as it relates to those anti-discrimination laws. So transitioning just a little bit to safety and OSHA, the baseline requirement for all employers is to provide a safe workplace, which I think all employers would agree. We want our employees to be safe, but there's a lot that goes into that. There are also a number of OSHA logs that need to be maintained for certain employers. So generally speaking, most employers with more than 10 employees and employers that are in like not in a low hazard industry, they must maintain injury and illness logs. So we may have some nonprofits on this call that are either less than 10 employees or don't work in high hazard sectors. This would not apply to you. We might have some trades on this call, and maybe it's maybe you're a company that has like 15 employees, you do plumbing, right? Well, that's a higher hazard industry. You would be subject to these OSHA requirements. There's various logs and reports and annual reports that you are required to do. I'm not going to go into the details here, but just know that you do have those expectations if you're over 10 employees in industries that are not low hazards. It's important to train employees on the hazards and also important to document workplace injuries. So then we get into more of the leave laws. I don't know that we necessarily have anybody on the call who has more than 50 employees, but there is the Family Medical Leave Act. If you are more than 50 employees, you are required to hold somebody's position for a qualified reason for themselves or for a dependent to hold their position, continue their benefits for up to 12 weeks. And so that is a piece of legislation that may apply to some of you. We did already talk about the ADA, which mostly will look like accommodations in the workplace, but sometimes those accommodations can come in the form of a leave. So what I mean by that is sometimes you have an employee that maybe just needs a short duration of absence because of their disability. So maybe it's 2 weeks, maybe it's 4 weeks, maybe it's 6 weeks. It's not so much about the length of time, it's more about, is there a defined end date to when they need to be off? If it's like an open-ended kind of thing where it's like, we're not really sure when we can come back, that's not a reasonable accommodation. That's going to create an undue hardship for the business, and therefore you're not required to provide it. But if you've got somebody that the doctor says just needs to be out for 2 weeks due to a flare-up on their disability, that more likely than not is going to be considered a reasonable accommodation. Certain states and certain localities have different paid sick leave benefits. That's become more commonplace across the country. Military leave. What most employers do not realize is that every employer in the US, even if you have just one employee, is subject to something called USERRA, USERRA, for military leave. And so basically with military leave, it's going to provide the opportunity for employees who are obligated for military service. It's going to provide them reemployment rights, seniority and benefits when they return, protection against discrimination and retaliation, and continuation of their health coverage at their expense. So there's a lot that goes into that. And I think it's just important to note that small businesses and nonprofits are not exempt from those requirements. And the last thing here is, and I know it's going to sound silly, but it's really about the verbiage. So when you're writing your policies, generally speaking, when you're writing your paid time off policies, and that could be PTO or it could be vacation sick if you split it out. When you're writing those, you generally want to use the term accrued and not earned. And why that makes a difference is when you use the term earned, it typically makes it look like a wage and therefore required to be paid. If you are doing, and if you're using the term accrual, when you have somebody separate from the employment, you are not required to pay out that accrued PTO unless you choose to. A lot of employers certainly do. A lot of employers will say, if you give me 2 weeks notice or whatever the required notice is, I will pay out the accrued PTO, but you're not required to. But then you're stuck if your policy says earned. If it's using the term earned throughout, you're more likely than not under the law going to have to pay that PTO out to the employee, even if you don't want to. So just be kind of careful about how you word some of those policies. Additional information about terminations. So employment at will. The vast majority of the United States operates under an employment at will arrangement. What this means is that the employee or the employer can decide at any time, for any reason, and without any notice to discontinue their employment. And it sounds great, right? Like, if I decide today I don't want to do this, then I can up and go. And as the company, I can decide I don't want to have this employee here anymore. Well, it sounds great until you as the company decide just kind of like we're done. But it's really not a get out of jail free card. You really want to make sure that when you are considering a termination decision, that you're really looking at that decision through all the lenses of the protected classes, right? And then also thinking about really it's the right thing to do. Have we done our due diligence as the employer? Have we really given this employee a fair shake to be able to correct their performance deficiencies or their behaviors? There's a lot to think about, and not just to say, well, we're employment at will and we can do this. There likely are going to be repercussions on the back end, whether it relates to unemployment or an EEOC claim or any number of things. So it's better to kind of really think about that more strategically before you make that decision. Um, I would also mention here, it's really better, it's probably better to not have policies if you're not going to follow them. Um, I strongly encourage policies, but then if you've got them documented and well communicated with the employees, the minute that you start to not follow them, that's where you kind of go awry. So if you're not planning to follow your policies, again, with some caveats, maybe you have some circumstances that require you to sidestep those policies on occasion. If you're not going to follow those policies, it's better off just not to have them. So that would be my encouragement there. And then the last thing related to terminations is COBRA or mini COBRA. So COBRA is essentially the opportunity for employees to continue their health benefits at their own expense for typically a period of 18 months. You can go longer for certain situations, but generally 18 months. So when you're doing terminations, it's really important to understand the notifications that you have to give to those employees about their COBRA rights. A lot of companies, just to kind of make things simple, will outsource that to a vendor, which I strongly encourage. I've worked for companies that do it in-house, and it can be done there as well. But you have to provide those COBRA options and those notices to employees within certain timeframes so they can make the elections if they wish to. There is also something called mini COBRA, which not a lot of people know about. So most states, Pennsylvania included, do require employers who have less than 20 employees, require them to make COBRA available to their terminating employees, just like as if they were a COBRA employer. The difference is it's generally going to be for a shorter period of time. So in Pennsylvania, instead of having to offer COBRA for 18 months, you only have to offer it for 9 months. So kind of a not very well-known requirement of those smaller employers, but offering that mini COBRA is something you should think about when you are terminating an employee, if you're less than 20 employees total. Layoffs and restructuring, kind of, following down the termination path here. So there is something called the WARN Act, WARN, generally applies to employers of 100 or more employees, so probably not relevant to anybody on this call. But if it were to apply to you, this generally means that you have to give a 60-day advance notice warning to employees that they will be losing their jobs. And there's like a public posting and all of those kinds of things that need to happen. When you are thinking about doing layoffs or restructuring, I would strongly encourage you to run all of the data on your employees. So let's just say, aside from just laying off one person, let's just say you're doing a layoff of a whole bunch of people, but not everybody in a certain unit or even across the company. Run your data and look at things like age and race and sex. Like look at those data points and see if you see any themes in terms of some discriminatory impact that could have occurred. You're not trying to be discriminatory, but it's important to look at the data to see if you've got some patterns there that could get you in trouble down the road. So kind of looking at your restructuring and layoff decisions through that lens is super important. Preparing talking points and written documentation. It's important to note that if you're going to offer severance, which is a really wonderful, generous benefit if you can do it, when you are offering severance benefits to employees who are over 40 years of age, you have some different requirements in terms of information that you have to give them. There's something called the Older Workers Benefit Protection Act, which really just kind of guides what you have to do in those scenarios. And essentially what it does is it provides those employees who are being separated with the information they need to make a good decision on whether or not they want to sign the severance package and waive their rights to age-related claims against the company. So just kind of be aware of those kinds of things. And the last thing here is just really handling somebody's final pay and benefits appropriately. Sometimes I'll get the question, well, if I have somebody who is leaving the company either due to a layoff, restructuring, resigned, whatever, and they don't return the company laptop, well, what's my recourse? Well, that is company property and there's a value attached to that, but you cannot withhold more from an employee's paycheck, even if the laptop is worth $2,000. You can't pay that employee anything less than the equivalent of minimum wage in their last pay. So if you can collect a portion of the laptop down to that minimum wage, great. You've satisfied your requirements, and then you can attempt to get the money back a different way. They can write you a check or whatever after the fact. But you have to be very careful about not taking too much from an employee's final pay to be able to recoup on company property that has not been returned. One other kind of small thing that I've run into it over the course of time that I think is not something often thought about is when you have those final pays that happen and you have a retirement plan, you really need to be familiar with your plan document to see how that plan document clarifies when final deductions for the 401k or 403b should be taken and when those deductions should be matched. Sometimes the plan document will say, no, those post-severance benefits, say like your PTO payout or whatever, it's not considered an eligible wage for those deductions. Other plan documents might say, yes, that's considered eligible compensation, and therefore you should withhold the 403b, 401k, and do the match. So just really being familiar with your plan documents in terms of how you process final pays and also benefits related to those pays. So we're kind of getting to the end here, but building a compliance foundation, just a couple of encouragements, a few kind of repeats here. Maintaining an updated employee handbook. It's great if you have one. It's not great if you wait, 3, 4, 5 years to update it because things change and things rapidly change. So really just maintaining a handbook that's current. Conducting periodic policy reviews. We know that the world is rapidly changing, processes change, titles change. Really just doing a periodic review of your policies to make sure they're fresh, current, and relevant and working for your organization. Training supervisors annually, very important, especially as it relates to workplace discrimination and harassment, those kinds of things where you really want them to be dialed into looking for things that may need to be addressed and also helping them understand like what their obligations are as supervisors and managers. I always encourage people to seek legal guidance when you're unsure. If you're not sure, like ask the question. I don't think there's any weakness in asking a question. Better to ask the question on the front end versus trying to clean up on the back end after making a not so great decision. And then establishing a documented complaint procedure is a good idea as well. So key takeaways, I kind of referenced this early in the presentation, but documenting everything. I often say, like, if it's not documented, it didn't happen. You don't have a way to prove it, right? So document as much as you possibly can. Secondly, invest as much time as you can. And I know time constraints are hard, but investing as much time as you can in creating and implementing clear policies and training. And then, like I just said in the last slide, when in doubt, just ask. Ask before you act. It's better to have an understanding of what to do on the front end before trying to clean up on the back end. All right, well, that takes us to the end here. Let me just check the chat and see if there are any questions. Doesn't look like we have any questions at the moment. I will leave it open here for another minute or two to see if any questions come in. I see some folks typing, while you're typing, in case there are any questions. Appreciate everybody's time today. I hope it was helpful. I know sometimes it can be overwhelming, especially if you're not super familiar with employment law. But I am happy to answer additional questions, either in this setting or offline. My desire really is to come alongside of, like I said, small businesses and nonprofits, help you be successful, right? On the compliance front. And we didn't talk about culture a lot here, but happy to help you on the culture front as well. So please do not hesitate to let me know. So we did have a question here that says, when it comes to exempt employees and tracking PTO, what can you ask these employees to track or record in terms of hours worked? So it is absolutely not a problem to ask exempt employees to track their PTO. My encouragement to you would be not to ask them to track or request time off in very small increments. I've seen it done a couple of different ways. Certainly, if you're asking exempt employees to submit PTO in 15-minute, half an hour, 1 hour increments, you're going to get yourself in trouble. It makes it look like you're treating that person or should treat that person as a non-exempt employee. If you're doing anything like a half day or a full day, you're probably good in that regard. But it's not a problem to ask them to track that time, just not in super small increments. What else? Anything else? Alrighty, well, I think that brings us to just about 2 o'clock. And again, appreciate everybody's time, and I hope you all have a great rest of your afternoon. Thanks for attending.